Welcome! If you're looking for efficient, focused learning, you are absolutely in the right place. In today's explainer, we're going to navigate the often intimidating world of civil disputes. But we're doing it without all that courtroom dread. We'll be drawing directly on some really practical insights from mediator Shelley Bose to show you how to put yourself entirely back in the driver's seat. Let's jump in.
So, are you dreading a lengthy, costly court battle? Look, it is incredibly common to feel completely overwhelmed when you're faced with a civil lawsuit. Whether it's a property issue, maybe some trouble at work, a messy landlord-tenant argument, or a broken contract, honestly, just the sheer stress of the unknown can be paralyzing. The traditional image of a trial, the strict judge, the crowded courtroom, and that massive legal bill waiting at the end, well, it's enough to make literally anyone anxious. It's entirely valid to fear that whole process. But here's the good news. There's actually a really powerful alternative.
To keep things super easy to digest, here's our roadmap for this explainer. 1. The litigation alternative. 2. Defining mediation. 3. The key advantages. 4. The process steps. 5. Who's actually in the room. And 6. We'll answer the big question. Is it binding?
Okay, Section 1. The litigation alternative. Finding a better path forward. When people get into a legal dispute, they almost always assume they're locked into this slow, agonizing march straight toward a trial. But civil mediation? It gives you a real choice besides regular litigation. It's a proven, structured method that actually empowers both sides to work together and find an acceptable solution. And it completely removes the intense pressure and hostility of a public courtroom. Basically, you don't have to hand your fate over to a judge.
Let's move to Section 2, defining civil mediation, what it is and exactly how it works.
At its core, civil mediation, which is a form of alternative dispute resolution, or ADR, is a private session where a neutral mediator helps opposing parties communicate and craft a mutually acceptable solution. And the absolutely crucial word here is neutral. The mediator is not a judge. They aren't there to decide who wins or who loses. Instead, their whole job is just to guide the conversation, clarify the messy issues, and help you find some common ground, making sure that you stay in control of the actual outcome.
Now, we really need to highlight the stark contrast between mediation and arbitration. People mix these two up all the time because they're both types of ADR, but they are vastly different. In arbitration, a neutral person listens to both sides and then makes a binding decision that you absolutely must follow, kind of like a private judge. Mediation, on the other hand, is completely non-binding during the actual process. You don't have to agree to any result you don't like. It's entirely mutual. That means if you don't reach a deal, you still have the exact same right to take your case to court. So it's remarkably low risk.
Section 3. Key advantages of mediation, and really why you should choose this path.
Let's break down this matrix, comparing traditional litigation and mediation. We'll start with cost because that's huge. While traditional lawsuits can easily drain tens of thousands of dollars in attorney hours and court fees, some legal retainers famously start at 10 or 20 grand before you even step foot in a courtroom, mediation severely cuts those costs. You don't even have to pay for expensive experts to testify. Next up, privacy. Court cases become public record. Anyone can look them up. But mediation is 100% confidential. What you say in that room stays in that room. And if you don't reach an agreement, nothing said in mediation can be used against you in court later. This creates an incredibly safe space for honest, open negotiation.
But the single most crucial advantage? One day. That is the dramatic speed advantage of mediation. While traditional lawsuits drag on for months or even years, totally draining your time, your energy, and your money, a mediation session is very often finished in just one single day. You can literally walk in with a massive, stressful problem in the morning and walk out with a signed resolution by the evening. It's a real game changer.
Furthermore, mediation gives you what we're calling ultimate flexibility. Think about it. Courts are rigid. A judge usually only has the power to award money. But mediation allows for some wildly creative solutions. You can craft non-monetary terms. You can focus on preserving a business or personal relationship that a harsh litigation battle would just absolutely destroy. You can even design highly customized payment plans or schedules that actually work for both parties' real-world finances. It's dispute resolution that's tailored entirely to you.
Moving on to Section 4, the mediation process steps, navigating the day.
Fear of the unknown is a huge barrier for a lot of people. So let's systematically walk through exactly what happens chronologically. It's a very structured journey. Step 1 is the mediator's introduction, where they lay out the ground rules and set a really calm, constructive tone for the day. Step 2 involves private caucuses.
The mediator typically separates the two sides into different private rooms, so no, you aren't forced to just stare down your opponent all day. Step 3 is negotiation. The mediator acts sort of like a diplomat, going back and forth between your rooms, sharing offers, highlighting the strengths and weaknesses of each side's case, and trying to help everyone find that middle ground. And finally, step 4 is the settlement agreement, where, if an agreement is reached, the mediator helps draft the final paperwork for everyone to sign.
Section 5. Who is in the room? Let's look at your cast of characters.
It's important to notice the carefully controlled cast of characters required for this to actually work. First, you have the disputants, so that's you and the other party. And it is absolutely vital that whoever is there has the actual legal authority to settle the case that day. Second is the mediator, who, as we've learned, is your strictly neutral guide. Third, you have your legal counsel. Your lawyer is right there beside you the entire time to give you legal advice and fiercely advocate for your best interests. And finally, in specific situations, like maybe a personal injury claim, insurance adjusters might also be present to authorize payouts. The key takeaway here is that everyone in that room is there with one single goal: to find an answer, not to make the problem bigger.
Finally, Section 6. Is it binding? Let's talk about finalizing your dispute.
So here is the critical question that worries so many disputants. Are mediation agreements actually legally binding in civil cases? After all, if you just spend a whole day talking, does it actually carry real legal weight, or is it just kind of a friendly chat that the other side can just walk away from tomorrow?
The answer is very clear and, honestly, incredibly empowering. While the negotiation process itself is totally non-binding, meaning, again, you can walk away at any time before a deal is reached, the exact moment both parties sign that final settlement agreement paper, everything changes. Once signed, the settlement agreement becomes a legally enforceable contract. The law respects it, and the court absolutely can and will enforce it if someone tries to back out. It provides absolute finality.
This quote, directly from our source material, perfectly summarizes everything we've been talking about today. Mediation is a way of dispute resolution that lets you keep control over what happens next. You aren't leaving your life, your business, or your hard-earned finances in the hands of a stranger in a black robe. You are actively participating in the solution.
So I want to leave you with this final thought. Are you ready to take control of your dispute resolution? If you're facing a legal conflict right now, I hope this explainer has shown you that you absolutely don't have to surrender to the anxiety and the massive expanse of a courtroom. Mediation offers a confidential, flexible, and highly effective path forward. Just think about what a difference it could make to completely resolve your dispute in a single day. I strongly encourage you to consider this empowered approach and maybe seek out some professional advice to see if it's right for your situation. Thanks so much for joining me for this explainer, and as always, keep learning.